Good morning and good afternoon to everybody. My name is Shantan and I am the event manager with Compliance King Corporation and would be your today's host. Thank you everyone for joining in today's live webinar preparing for Imminent Federal HIPAA Audits. Today's presenter is Brian L. Turtle. I will quickly introduce Brian. Brian is certified professional in health IT, certified HIPAA professional with over 17 years experience in health IT and compliance consulting. Brian has worked for all of those 15 years with MAG Mutual Healthcare Solutions and is now senior compliance consultant. Brian is well known and highly regarded in medical circles throughout the US. Brian has a master's degree in health science from Georgia State University. Now, before I hand it over to Brian, I should inform you that the session would be of 60 minutes. Also, we have a Q&A session at the end of the webinar. You can keep sending your questions through chat window and Brian will answer those questions at the end. We will begin now. Brian, I will request you to please start the presentation.
Already good? Sorry about that. I don't know what occurred with my connection here, but anyway, just a quick background. I've been doing HIPAA compliance consulting for about 15 years now and have done over 1,000 risk analysis throughout my career for covered entities as well as business associates of all shapes and sizes, and also worked on behalf of the federal government as a contracted auditor. So I've seen things from both sides of the coin, both from what the federal government is actually looking for versus what we think they're looking for. And more importantly, these days especially, I've worked in multiple litigated cases where HIPAA is being used as the foundation of a state case of negligence. So the fact that individuals can now sue under their state laws for HIPAA violations has really upped the game here for all of us. And in either case, whether you're being audited by the federal government or, God forbid, we're being sued under a state case of negligence, invasion of privacy, or what have you, we have to prove that we've been proactive and not reactive in our compliance. And I'll get into some details with that as we move along here. So just real quick, a little background. The law was pinned into legislation back in 1996, known as the Health Insurance Portability Act. Obviously, it's morphed and changed quite a bit through those years. It's interesting, though, when we think of the word HIPAA, most of us think about securing protected health information, making it accessible to those who request it, but that's really not what the law was about at all. It was about portability of health insurance at its inception. It's always been bipartisan legislation. This is one area up there in Washington they actually agree on. Even from its inception, it was bipartisan legislation, and there have been calls from both sides of the aisle for more increased security of our health records and more increased enforcement of the HIPAA laws, which really kicked in late 2013 and when the HIPAA Omnibus Rule went into effect, where true enforcement really began. The acronym is the Health Insurance Portability and Accountability Act of 1996. Two key words missing from that acronym are the words privacy and security. Not even in the acronym, but by far, the HIPAA privacy and the HIPAA security rule are our biggest challenge, and that's what we primarily face as compliance officers. The problem with the law is it's very abstract. A doesn't equal B. A equals whatever risk dictates it equals. So there's no silver bullet. And when you think about HIPAA compliance, you have to move your analytical way of thinking, take off your analytical hat, and you have to think abstractly. Everything with this law is based upon reasonable and appropriate due diligence. Just remember that. A doesn't equal B. We all follow the same guidelines, but the way you implement those guidelines are entirely different for, let's just say, a tiny little medical practice in Southeast Georgia versus a great big hospital in Manhattan, New York, for example. So, and that's what, when we are audited, that's understood by the auditor. They don't expect the same thing from the small practice that they do from a very robust, large hospital with thousands of working parts, although we still need to be proactive and prove that we are implementing these requirements that are required under the law. The Boy Who Cried Wolf is a very good acronym, or not acronym, but a very good way to sort of explain how the law has been. If you think of the Boy Who Cried Wolf, the old fairy tale, the little boy screams, wolf, 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 and there was never really a wolf there. That's sort of how the federal government has been with HIPAA. Came out back in 2003, federal government says, do this, do that, do this or else, do that or else. Then we had the HITECH Act in 2009. You got to do this, you got to do that or else. Well, they never really implemented the law, or enforced the law, I should say. Because think about it, how often in the past did you hear of a group being audited, or a group being sued, or someone being heavily fined for HIPAA? Hardly ever. I mean, yes, it happened, but really the only way you would get an audit back then is if you had an actual breach, or if someone filed a complaint. There was no proactive auditing going on. They weren't really implementing this. Yes, it was on the books, but what's the point of a law that's not being enforced? So you ran into a situation where many groups just swept it under the rug. Medical practices, hospitals, you may have had something in place, but there's many other pressing issues, so folks just ignored HIPAA in a way, and unfortunately, the wolf has arrived. And I jest with these pictures, but I get calls literally every day. And I've been doing this a long time, since 2003, and I get calls every day now from groups all over the country stating, oh no, we are being audited by the Office of Civil Rights for HIPAA violations. What do we do? What do we do? Or we're being audited just to see, just in general, because nothing occurred. You're just being proactively audited for bad luck, essentially. And that just was unheard of in the past. There may be an audit back then, but you had to have a breach of sorts to stimulate that audit. So definitely the proactive auditing, that coupled with the ability for folks to now sue under state laws, that has greatly increased your risk for an audit. Because in order to sue under state laws, one must first file a complaint with Health and Human Services about some alleged violation. No matter how nominal the violation may be, the federal government will investigate. And while they're investigating, they're not only going to investigate the complaint itself, they're also going to be asking you about your compliance program. Show us proof that you have policies in place. Show us proof you train your staff. Show us proof you've done risk analysis. Show us proof that you have physical security in place, administrative security in place, technological securities in place. Show us proof of these policies. And if you don't have those, you end up getting fined for something totally unrelated to the original complaint. It's sort of like being stopped at a DUI checkpoint. You're not drunk, but you have a tail light out, so you get a ticket for that anyway. That's really upped the game, because more and more folks file complaints than ever before, because that's the first step you take if you're going to take this into litigation under your state law. But in either case, whether it be the federal government auditing you or being dragged into litigation, you've got to prove you were proactive before this situation occurred, because if you can't, you're going to have trouble. So when everything really changed was September 23rd, 2013. That's when the Omnibus Rule went into effect. Prior to that date, as I stated, we were dealing more with this little poodle. That's what we were dealing with. Yes, the law had teeth, just like the poodle. It's got teeth. It can bite you. It can be generally annoying, but it is not an imminent threat. Unlike the honey badger, that's what we're dealing with now. After that date, September 23rd, 2013, we are dealing with a much more aggressive law than we were before. 9/23/2013, what was that, a little over 3.5 years ago at this point. That's when true enforcement began. But as you know, when the government does things, it's slow. It's sort of like turning an aircraft carrier around in the Mississippi River. So it takes a little time for traction to begin. And the government is full bore in terms of the proactive auditing they're doing. In addition, attorneys have picked up on the fact that folks can now sue under state laws of negligence for this, and that is causing more and more audits also. So what really changed? Increased penalties. The burden is also equal between the covered entity and business associate. That's very important to understand. I don't know how many folks on this call are business associates or covered entities, but keep this in mind. If you are a business and you notice something non-compliant in the way in which you do business with the covered entity, but yet you still continue to do business, you are now complicit in the non-compliance and would be held accountable by the federal government and fined accordingly. And also you would be held under a state law if sued in some kind of class action lawsuit due to a breach, because you should have known the non-compliance occurred and stopped doing business. Let me give you a real-life example of this. I dealt with a case where a very large medical practice, 25-doctor practice, got breached, got ransomware, and got hacked through one of their business associates because they were letting this outsourced billing company in, who was the business associate, sharing the exact same usernames and passwords for all 10 of their employees who were working the account. Well, they got breached through that because that is very bad access controls and multiple levels of HIPAA violations there. The business is just as guilty, though, because the business should have told the practice, look, we can't come into your system this way sharing this same username and password. All 10 of our staff members must have individual usernames and passwords because it's not HIPAA compliant to do it the other way, because it's impossible to audit user actions if we're all sharing the same passwords. It's a violation on multiple fronts under HIPAA, but they didn't. They continued to accept the access. A bad situation occurs. Both the practice and the business have had to pay out large judgments in a class action lawsuit from the 201,000 people who were wrongfully breached in that particular case. So very important. If you're a business, you have to understand this is a bidirectional street now. It's not just all on the covered entity as it used to be. Greatly enforces proactive federal auditing. Last year, 2016, we saw records. This year, we're going to break 2016 by the end of this month in terms of how much revenue the federal government brings in for HIPAA violations. Two reasons: proactive auditing and primarily the individual remedy. More people file complaints than ever before. Complaints get investigated. So the 2009 HITAC Act came out. You may be familiar with that. That added teeth to the legislation back in 2009. That was when there was funding for implementation of electronic health records, but with that funding came more restrictions and more laws on the books, but not true enforcement. I added the Affordable Care Act here only because people keep asking me questions about that. Will something change should the Affordable Care Act get repealed? No, nothing will change at all under HIPAA, or at least under the enforcement of HIPAA, because that has nothing to do with the enforcement of HIPAA. Now, the Omnibus Rule of 2013, which is what I've been talking about, that's where we have direct mandate that Health and Human Services utilize the Office of Civil Rights to begin this audit process. The Office of Civil Rights is who enforces the HIPAA privacy and security audits, because it is a civil right every American enjoys that our health record be accessible as well as secured. So hence the OCR does the enforcement of that. Historically, this has been a benign law. As you know, no consequences for actions in most cases in the old days, more of a nuisance than a real problem. Fines were low and rare. Audits were very rare back then, and only the federal government could impose fines on behalf of a patient, nothing for the patient. That hasn't changed, not under federal law. Uncle Sam will still be imposing fines, but what the feds did is they told the states to implement those laws of remedy so an individual can get remedied under the state law. And don't get me wrong, if someone's been violated their health record, you should have a remedy. No one's arguing that, but this is the United States, and we sue over everything in this country, and this has been picked up on. And the reason I'm harping on this so much is because this stuff goes hand in hand. More people file complaints, more audits. Whether you're being audited by the feds or you're being dragged into litigation, you have to do the same things. Provide proof that you've done what we're supposed to do under the law, under the HIPAA laws. Provide proof of risk assessments, policies and procedures, that we train staff, all of these things, same concept. Audits have begun in earnest. Big, small, short, and tall, it does not matter the size and scope of your group. You are still at risk, and unfortunately it is the smaller medical practices statistically that suffer the most. Another statistic, at this point, 80% of groups that are being audited are covered entities, meaning medical practices, hospitals, insurance plans, outpatient facilities, groups that are providing health care at this point. Now, that's subject to change pretty soon, and I'll explain why later. Clearinghouses and insurance companies are also at risk, and the federal government is not accepting the same old excuses as they had in the past. So, last year, when any time this year too, obviously, we all have a personal responsibility here, and this is very important. You need to let your staff members know and train them and have them sign off that they understand there are personal, civil, and criminal responsibilities under HIPAA that we all have. So basically, let me give you an example of how important this is. I dealt with a case where a young lady who worked at a OB clinic, she went into the health record of the ex-boyfriend's new girlfriend, and she disclosed verbally and through social media some very, very sensitive information about the ex-boyfriend's new girlfriend that she had looked up in the health record, within the electronic health record. Well, she's in jail. She faced up to 10 years in federal prison for that, because that's the top tier of a HIPAA violation that you can do, is using the information that we're privy to for malicious intent. That's what that was, malicious intent. 10 years also for identity theft or trying to sell information, those sorts of things. Now, the reason I'm telling you this is, of course, the person finds out, comes straight to the practice, says, I know this happened here. I want you to find out if she went in my health record. And sure enough, this electronic health record system that they use, just like any EHR system, can ascertain every single thing that we do. So she went into the record. She could see how the manager, meaning the compliance officer, the practice manager, went into the health record. She could see how many times that staff member went into the record, what she changed in the record, how long she was in the record, and when she accessed it down to the second. So that is a violation, a gross violation of that individual's civil rights. Now, the individual goes and hires an attorney. First, they go to the Health and Human Services, file the federal complaint. Federal government says, yes, this is a massive complaint. We are now going to investigate and audit. So the federal government investigates and audit. They then go to a state judge. They go file a lawsuit for negligence against the practice, because they're not going to file a lawsuit against the individual. They're going to jail for a long time. They're not going to have any money anyway, usually. So who are they going to sue? They sue the practice. In this case, the federal government audited and did not fine that practice one penny. The judge in the state case of negligence threw it out. Why? Because the practice wasn't negligent. When they hired that person, they background checked her, they vetted her. She signed off on confidentiality agreement upon hire not to do these things, that there are strict civil and criminal personal responsibilities here. They formally trained her. They trained her annually. They had policies and procedures in place for system auditing. All staff members were also trained to understand everything they do inside the electronic health record system is tracked. They had all the mechanisms in place. They were not cavalier. They did what they were supposed to do. Therefore, they were not negligent. This is an individual problem. Other staff members were deposed and questioned not only by the federal auditor, but also in court. Questioned, well, in deposition rather, that did you know it was a violation to do this? Yes, we knew that. They all knew that. So bottom line, practice wasn't being negligent. And I'm telling you that because that's why it's so important to get in front of this law, not behind it. Not just for federal audits, but because there's that higher risk even than the government of individual remedy. Very important. Can we be fined for violations even if a breach doesn't occur? Yes, absolutely. Remember, this isn't just about securing health records, but you could be held accountable and be audited. For example, if I walk into your practice and I say, I want my health record, and you say, no, Brian, we're not giving you your health record because you owe us money. Well, it's my record. It would be nice if I paid my bills, but it's still my record. Or I come in your practice, I say, I want my health record. You say, no, we're not giving you your health record because half of this health record was created by a doctor not affiliated with us. Does not matter, still my health record. You could be fined also if you have an electronic health record system, the server dies, your backups are no good, and you can't get those records back. So you've lost all of your data, and you cannot get those records back because a patient has a civil right to their electronic health record. We must be able to provide that in a, quote, reasonable time frame, even in the event of a disaster. So that would be another way you could be fined even if a breach doesn't occur. You could be fined even if a breach doesn't occur if you get audited proactively and you have no program in place. You have nothing, or very little. You haven't done a risk assessment, or it's very old. You don't have policies in place. You can't prove you've trained your staff. You don't have a disaster recovery plan in place. You can't prove you've been proactive. You could be fined for that, even though a breach has not occurred. Now, business associates. I don't know who all on this call is, or on this webinar is covered entity or a business, but businesses are directly in scope now. Even though most of the audits that have occurred right at this point, 80% have gone against covered entities. That will be changing down the road. So business associates are individuals or entities who create, receive, maintain, or store PHI on behalf of a covered entity. Answering services, medical transcription, IT groups, billing companies, shredding services, attorneys, collection agencies, all sorts of third-party ancillary groups. Now keep in mind, there are over 7 million business associates in the United States and about 900,000 covered entities. So there's many more business associates than there are covered entities. But a lot of times business associates can be really, really small, like an IT guy, just a one-guy break-fix IT guy. That's technically a business associate. The ones that are at a higher risk of being audited are the larger groups, the billing companies, the third-party administration, credentialing groups, TPA, I already said that, transcription groups, attorneys, the larger IT groups, things like that, collection agencies, shredding services. Now, businesses these days have to develop policies and procedures for HIPAA. They have to train their staff. They have to conduct their own risk analysis. They're, of course, subject to being audited. And again, remember, it's a bidirectional street. They have to monitor the covered entity where an agreement exists, at least in the way in which they do business. Business associates must also have agreements in place with their subcontractors. So if an outsourced medical billing company subcontracts collections to a third party, that third party is now in the realm of HIPAA as the subcontractor of the business. If a breach occurs, a business must notify the covered entity the breach occurred. Covered entity then notifies patients. Very, very critical. If a breach occurs, you must notify. If a breach occurs, you know it occurred, and you don't notify, you're going to have hell to pay with that, because that is not only unethical, it is highly, highly very high violation under HIPAA, and borderlines into the area of criminal if there's a breach and we try to cover it up. There's been medical practices put out of business for that, and huge fines. Now, the director of the Office of Civil Rights at the end of 2016, and we have a new director at OCR, but both the directors, Jocelyn Samuels, who was the previous one, and the new one, Severino's his last name, I forget his first name, but they have the same concepts on this, even though both were appointed under a different administration. Remember, this area is not an area of contention in Washington. Both have the same concepts on enforcement of security of our health records. So, with the revenue being brought in from the audit process, the federal government hopes to recoup losses for meaningful use Medicaid and Medicare payouts. Meaningful use is gone. That left in the end of 2016. We now have the MIPS program, but the same concepts apply. The new OCR director basically has stated the same course will be maintained in terms of enforcement of the HIPAA privacy laws. I expect we're going to see large monetary settlements for a long time to come. Bottom line, this is a money-making venture. Roughly for every dollar spent, 20 is brought back in revenue. The reason the government does so well with this is because they outsource it. It's not feds necessarily auditing you. It's outsourced. I've done it. I don't work for the federal government, but I've worked under contract for the federal government. These are not rack audits, though. You don't get paid for what you find. But if you never find anything with a law such as HIPAA, which is very gray, you're not going to keep a contract for very long. And again, auditors are very reasonable as long as we can prove, as a covered entity or business can prove they've been reasonable. The problem is, though, it's literally just the low-hanging fruit everywhere out there because groups have not done what they're supposed to do. There's so many that are not compliant with this law, easy pickings. So when an auditor comes across a group that has done their due diligence, they typically just move along. Because you get audited, they ask you to provide various forms and documents, typically remotely, into the OCR's portal. If you can do that proactively, you're not going to have a problem. Now, real quick, let's talk about suing, and then we'll get into the specifics of auditing. So we have to talk about these two because you can't have one. Well, you can't be sued without an audit. You can certainly be audited and not be sued. But bottom line is, just remember, nobody can sue under HIPAA. That is a federal law. You cannot sue under the federal HIPAA or any of its violations. Nobody has a right to sue on a violation of HIPAA by itself. What most folks don't understand about HIPAA is that as extensive as the statute is and as serious as the penalties are, and they're very, very serious, there is not a private right of action written into HIPAA. So the federal government fixed that because they told the state's attorneys generals to implement laws of remedies. So although the 2013 modifications made no direct impact, they made massive tangential impacts because the feds told the state attorney general to implement civil action statutes that folks can get remedied under state laws. And this attorneys have picked up on this. As I stated, it is shooting through the roof the amount of complaints being filed under this law. I've personally worked in over 27 states, or 27 to be exact, at this point as expert witness, and that's just me. So I'm pretty sure all 50 states have implemented laws of remedies. Hence, last year, we don't have statistics yet for this year, but patient complaints to OCR tripled. That's bad news because that's leading to higher audit risks. Even minor violations are being investigated. They investigate just about everything. And the minor violation may not even end up being anything, but they get you for something else. States are falling like dominoes. Individual court cases being filed citing HIPAA violations are creating precedents all over the country. Now, not to scare folks, but you really have to have a serious situation for there to be a civil remedy. You have to have verifiable financial loss, like a group was really careless with Social Security numbers, names, and addresses, and you got your identity stolen, or slander or defamation, something like that, then you may have a civil legal remedy. So let's talk about these Phase 2 audits that are going on, Phase 2 HIPAA audits. Let's just talk about what those are. You can go online at hhs.gov and read all about them online. I'm not going to read verbatim. There's just way too much. I'm going to go and sort of bullet point out what's going on here. But that's what it looks like. If you go online, that's what that link I just had there looks like, and you can certainly go to that link later. I'm not going to read this verbatim off the web page. Now, there's an audit protocol located also at hhs.gov through this link. It's a very, very long protocol that the government goes by when they audit you, and this is very robust, very robust. I've been putting together, I put together a new risk assessment based on this protocol provided to us by HHS, and you can do the same thing to self-audit yourself. So the audit protocol, this began over a year ago in April 2016. We're still going through this process of the Phase 2 audits. Now, these Phase 2 audits aren't as scary as they seem, and we'll get into the reasons why. So let's go through the main concepts of what's going on here. So OCR has begun its next phase of audits, and I use HHS OCR interchangeably. The Office of Civil Rights is a part of Health and Human Services. Audits are an important compliant tool for OCR that supplements their other enforcement tools, such as complaint investigations and compliance reviews. These tools enable them to identify best practices, proactively uncover and address risks and vulnerabilities to PHI. So the Phase 2 audits aren't necessarily they're coming after you to fine you, to throw fines against you. They're supposed to help us. The audit program is in place where OCR is going to review policies and procedures adopted and employed by covered entities and their business associates to meet selected standards and implementation specifications of the privacy rule, security rule, and breach notifications rules. They primarily will be remote desk audits, meaning no one on site. There may be some on-site audits, but more than likely remote. The process begins with a verification of your address and contact information. I'll show you the email shortly that's being sent and the questions that they ask. OCR is going to then transmit this pre-audit questionnaire, which I'll show you shortly, that has a lot of questions. They're very, very invasive. If you don't respond to these questions or you don't respond to the email they send, it does not mean you are exempt, not at all. So if you don't respond, you still may be selected for an audit, and they'll just use commonly known knowledge about your organization to make up their own ideas about your size and scope. Now, they expect us to check our spam filtering for their email that they're sending out. Another thing to be very aware of, it's kind of funny in a way, their email has been hijacked, and you may get a fake email from a phishing attack pretending to be from OCR, so be very careful about that. The audit program is developing on pace. OCR is committed to transparency. OCR has posted updated audit protocols on their website, and again, these are the protocols that I highly recommend you look at, because that's how you can self-audit yourself. They're updated to reflect the latest and greatest from the Omnibus rulemaking at that link. OCR will enhance industry. These audits are intended to enhance awareness of compliance obligations. These aren't really, these proactive audits that you may get under Phase 2, they're not necessarily out to get you and fine you or anything, but come to find out if you have nothing in place, it can end up being that way. And they're going to use the Phase 2 to implement Phase 3, which will be the permanent audit program that then we are, they will be more than likely coming after us and applying more punitive fines against us. Now, if you have a complaint against you, then yes, they are much more aggressive with that. So here's the general instructions for the what they're asking for in terms of the email that you may or may not have received. So let me show you what the email looks like. So basically, you'll get an email from OCR. It talks about that they're from the OCR, they're responsible for enforcing HIPAA through the American Recovery and Reinvestment, or the HITECH Act of 2009. Congress required the department to audit covered entities. They didn't really start in 2009. 2013 is really when they began putting the rubber to the road, and this 2016 audit process is part of the Omnibus clarifications of HIPAA. These present an opportunity for OCR to determine or examine mechanisms for compliance, identify promising practices for securing PHI that may not have come to light in the past, essentially. You're receiving this email. It's a questionnaire, remember. You've been selected to complete this pre-audit screening questionnaire linked below, which I'll show you. The questionnaire is intended to gather data about the size, types, and operations of potential auditees. The data will be used with other information to help the government select entities that reflect a variety of types, sizes, and locations for the next phase of the audit program. Receiving the notice, if you received it, maybe you haven't received it, but if you do, it does not mean you're being audited. It means you've been selected to fill out this questionnaire. They want to know some information about you, and then you submit your information into the portal of the federal government. You can also view the questionnaire at their website as well. Everything you do with OCR is done through their encrypted portal, so it's secured. Now, if you're selected for an audit, which you don't want to be, but if you are, you'll have 10 business days to respond with the requested documentation. 10 days, that's not a lot, especially if you haven't been proactive. OCR will use this information to compile a list of potential business associates subjects to audit as well. Now, here's where business associates come in. They want a list. The way they're figuring out who all the business associates are, because the federal government doesn't know who all of these 7 million business associates are. Therefore, they're requesting from covered entities a detailed list of who those business associates are. They want them in a specific template, which you can see at this link. They want to know primary and secondary contact names, titles, emails, phone numbers, addresses, websites. They want to know all kinds of information about these business associates. That's how they're finding out who they are so they can audit them next. If you're selected for an audit, it'll either be a desk review, meaning remote. It'll either be an on-site review, or perhaps a combination of both. Usually it's a remote audit. And by the way, they're not just going to show up unannounced. Highly unlikely they can. They have the right to do it. But I've been doing this a long time, and I haven't seen them just show up unannounced. So sincerely, this was the letter from last year. Same exact letter. It's signed by the new director of OCR, not Jocelyn Samuels. She's not there anymore. Now, question 1. Here's just the little questions you may get. Are you public or private? Are you a single location or multiple locations? Are you part of, affiliated, or otherwise owned or controlled by another organization? These are the questions you'll get. If you are owned or affiliated or otherwise owned or controlled by another organization, they want you to identify and describe the relationship. Are you a HIPAA-covered entity? That means, do you file electronically? Even if you're not a covered entity, that does not mean that you are exempt from securing health records to reasonable and appropriate levels. Don't be fooled that just because you don't meet the definition of a covered entity, maybe you're a plastic surgeon and you only take cash. You don't file electronically. Doesn't matter. You still have to comply with HIPAA laws. It's a little bit confusing the way the government does that, and I don't think it's fair. And I've made a point to let them know. They haven't changed it though. What type of provider are you? How many patient visits in the prior fiscal year? How many patient beds do you have, if applicable? What's the current number of clinicians on staff? What? Click properly there. Do you maintain or transmit PHI in electronic form? Do you use an EMR system or an EHR system? What's the total revenue for the most recent fiscal year? Are you a group health plan sponsor responding on its behalf? So some of these questions are kind of hard. You almost need an accountant for some of them. What's the total number of members within your health plan? What's the average number of claims processed monthly in the most recent fiscal year? What's the total revenue for the most recent fiscal year? Do you use a TPA in your functions? Then it goes on. If you are a group health plan sponsor, do you receive only summary data from the group health plan? What's the total number of transactions processed monthly in the most recent fiscal year? What is the current number of healthcare providers, health plans, and other entities served? What's the total revenue for the most recent fiscal year? All kinds of questions. Now we talk about getting into business associates. Do you operate as a business associate only and do not maintain any protected health information or perform covered functions as a covered entity apart from your activities as a business associate? Please briefly describe the nature of your business activities. Identify the types of covered entities for which you provide business associate functions. Identify whether any of the covered entities for which you provide business associate functions are OHCAs or ACEs. Identify the approximate number of each type of covered entity for which you provide business associate functions. Lots of questions here. Does your business associate activity, does it involve transmitting PHI in electronic form? Do you work in more than one state as a business associate? What's the approximate total revenue from all of your business associate activities in the most recent fiscal year? Now here's another audit letter. And I like this letter because this was from a claim. Someone submitted a claim or filed a complaint with HHS that ended up being completely false. Didn't even really happen as it was suggested. But nonetheless, this group had to jump through all kinds of hoops anyway. So basically, they received a complaint that some PHI was posted on this website. I'm removing the name of the website. It indicates that the patient had an account number with Kaiser Permanente Northeast. The allegation indicated potential privacy and security rule compliance failures of the following: risk analysis, which is an implementation specification, risk management, information system activity review, workforce security, audit controls, and transmission security. All of those are implementation specifications of the HIPAA security rule that they claim that this group is not in compliance with. Then it explains that covered entities and businesses must cooperate during a complaint investigation or review and permit OCR to access its facilities, records, or other information during normal business hours or at any times without notice if exigent circumstances exist. To the extent practicable, OCR will seek cooperation of an entity or a business associate to informally resolve the complaint. For example, OCR may provide technical assistance to help you or a business associate voluntarily comply with applicable provisions. Then they attach a list of all the information that they need. They need it within 20 calendar days that this group's being audited for something that really didn't even happen. So then they go on to explain that they have that you have the right to respond to an allegation by submitting evidence indicating that either you're not a covered entity or a business associate subject to these applicable provisions of HIPAA, or the violation did not occur as described, or the action complied with HIPAA, or the covered entity or business has taken a prompt and effective action to correct the problem. If we cannot resolve this matter voluntarily, and if OCR's investigation results in finding that ABC isn't in compliance with HIPAA, they may initiate formal enforcement action which could result in the imposition of civil monetary penalties. They enclose a separate fact sheet explaining the penalties, which I'll show you shortly. It also talks about the criminal penalties under HIPAA that the U.S. Department of Justice enforces. And then blah, 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 sincerely Donald Duck. And you'll get it from the regional manager wherever you are in that federal region. Federal district. So they need to know a written explanation of where this information came from. Got to do this within 20 days, even though nothing really happened. Copy of all response and investigated documents. They want the organizational structure of the place, of the covered entity or the business, who owns and operates the business, where they're registered to do business, and the phone number of the custodian of records. Copy of the most recent risk assessment. They will always ask for your most recent risk assessment in any audit you ever get. That's always going to be there. Copy of any and all policies and procedures on reviewing information system activity. They want a copy of policies and procedures that ensure all workforce members have access to PHI, but only appropriate access. They need a description of any and all audit controls on the server from which the PHI originated from. They need a description of the technical security measures implemented to guard against unauthorized access to PHI that's being transmitted between medical devices and ABC Inc. information resources. They need this within 20 days sent to the address below. Then they go further to explain that the privacy rules set standards for the use and disclosure of PHI by a covered entity and a business associate, and also set standards for providing individuals with privacy rights to understand and control how their health information is used and disclosed. The security rule sets a specific series of administrative, physical, and technical security procedures for covered entities and businesses to use to assure the confidentiality, integrity, and availability of electronic PHI. Security is electronic. Privacy covers all forms of PHI. Consistent with the principles for achieving compliance, OCR will seek the cooperation of us and may provide technical assistance to help us comply voluntarily with the applicable provisions of HIPAA. Covered entities and businesses that fail to comply voluntarily may be subject to civil, monetary penalties, and possibly criminal prosecution, which we'll explain. Let's talk about the money penalties. They may impose a penalty on a covered entity or business associate for failure to comply. Penalties will vary significantly depending on factors such as the date of the violation, whether we should have known of the failure to comply, or whether the covered entity or business's failure to comply was due to willful neglect. Now, willful neglect will be basically is determined on a case-by-case basis. Then they go on to talk about for violations occurring after the HITECH Act, which was back in '09, so pretty much everything, OCR may impose a penalty of $100 to $50,000 or more per violation with a calendar cap of $1.5 million. A penalty may not be imposed for violations in certain circumstances, such as if you can prove that the failure to comply was not due to willful neglect, or the failure to comply was corrected during a 30-day period after we knew or should have known that the failure to comply had occurred, unless they give us an extended extension on that. In addition, OCR may reduce a penalty, and this has happened, I've done this before, if they give what they're giving is excessive considering the extent of the non-compliance, if it's excessive. Before they impose a penalty, though, they will notify us and provide us the ability to provide written evidence of those circumstances that would reduce or bar a penalty. The evidence must be submitted within 30 days of receipt of the notice. In addition, if OCR states that it intends to impose a penalty, a covered entity or a business has a right to request an administrative hearing to appeal the penalty. Criminal penalties. Now, remember we talked earlier about the up to 10 years because of malicious intent, what that individual did. So a person who knowingly obtains or discloses PHI in violation of HIPAA may face a criminal penalty up to $50,000 and up to 1 year imprisonment. The criminal penalties increase to $100,000 and up to 5 years if the wrongful conduct involves false pretenses, and up to 10 years and $250,000 if the wrongful conduct involves intent to sell, transfer, or use PHI for commercial advantage, personal gain, or malicious harm. Malicious harm is what the example I gave earlier happened, and the DOJ handles that. And trust me, when you get tangled with the federal government and they are coming after you, it is not good. No one ever gets out of that stuff. So very important to train your staff. These are federal offenses. So what can spurn an audit? What are some factors that can just get us spurn audit? Well, internal staff. That's number one. Train your staff. We're made up of people. Train them. Make sure they understand their personal responsibilities. Make sure they know everything they do is being audited by the system. Patience, meaningful use. If you took money from the government, business associates, vet them. Don't do business with groups that you don't vet. If you've had a breach, that certainly can get us audited, not reporting a breach, and of course someone filing a complaint, which goes back to patience, and a disaster. If a disaster didn't go well, you couldn't get your information back. Not that any disasters go well, but we have to be able to get back the electronic health record even in the event of a disaster in a reasonable time frame. So if you had a site audit, a on-site audit, depending on size and scope, these audits would include interviews with leadership, which would be the practice manager if you're a medical practice, of course, privacy officer, security officer, which might all be the same person in a small group, chief information officer, legal counsel, medical records manager, examination of physical features, consistency of process to written policy. They will read your policies. They need to make sure policy equals procedure. So far, it's the small providers that have had the biggest problems, unfortunately. Healthcare providers and business associates in general have had many more issues in clearinghouses or insurance plans, and it's the security of electronic protected health information, the security rule, that has the biggest problems compared to privacy. Now, drilling down deeper, what specifically has been the problem? Number one area of compliance in terms of audits of people failing, risk assessment. It's not there, it's incomplete, it's old. Make sure, because that's the nucleus of everything. That's where we fix all these other problems. Lack of policies, lack of training your staff, lack of a written contingency plan or disaster plan, lack of proper auditing of your systems. That's required under HIPAA. Lack of a breach notification in place. If a breach occurs, we must notify. We have to have policies in place as to what we do if a breach occurs. If a breach occurs and we don't notify, that's big trouble. So that's one whole area that folks get fined on for not notifying, and serious trouble for that too. Weak IT support. Now that was not a federal statistic. I added that. IT is way too critical to trust the doctor's 14-year-old nephew to handle your IT or the business owner's drunk brother. Use professionals for this. It's way too dangerous because the cyber hacking is massive these days, and this is organized crime that will single out medical facilities, medical practices, any group that they think that they can trick into surrendering their information, or that they can trick into downloading ransomware. It's big, big business. If you do get an audit, highly, highly unlikely someone's just going to knock on the door and say, we're from the federal government, you're being audited. They're going to let you know when they come. So get your stuff together, employee handbooks, business associate agreements, a list of your business associates, any documents you have relating to staff training, confidentiality agreements, notice of privacy practices, assuming you're a medical practice, that is. Make sure those things are up to date. Update your policies where you need to. Make sure you're covering what you need to cover under HIPAA. Make sure you go through that. I would go through that audit protocol at the hhs.gov to make sure we are covering all of these implementation specifications. If you haven't done a risk assessment, well, you got to do one ASAP. Immediately. You may need to bring in a consultant at that point, or even an attorney. Explain to your staff what to expect. Be sure they know your policies. Explain to them about what low-hanging fruit is. You know, leaving passwords on sticky notes, not minimizing your screen, talking with patients on a speakerphone, just stupid things like that should be clearly covered. Don't be mean, don't be defensive. If you need to bring in outsourced help, that may help increase reasonable and appropriate due diligence if you need to do that. Risk assessment is the most important aspect. Get this done before something bad happens. Get those policies in place before something bad happens. I've never been a part of any audit, federal audit or litigation, where they didn't ask, where's your risk assessment? Submit to us proof it's been done. remember, when you do your assessments, this is not a perfect system. There is no silver bullet. There is no stamp. I deem thee HIPAA compliant. Doesn't exist. There is no such thing as HIPAA certifications, not from the federal government anyway. It's all about reasonable and appropriate due diligence. Now, there's a good tool out there that you can use at healthit.gov to do a HIPAA security risk assessment, but that's just for HIPAA security. That's not covering HIPAA privacy. Now, if you're just a business associate, normally you just need to do HIPAA security, not so much HIPAA privacy. HIPAA security is part of HIPAA privacy, okay? But privacy gets into a lot of areas about notifications to law enforcement, a 14-year-old pregnant girl, is she an emancipated minor? It gets into stuff about how long we need to maintain records, things that aren't so much technologically based. But both are important. We got to cover both. Very good document relating to HIPAA security is provided by NIST. Just like that tool, the tool provides the same basic things this document does, but some folks don't like to use the tool. I don't, because it's too quirky. So I just make my own risk assessment through a spreadsheet and use a lot of the NIST guidance to do that. And a lot of the questions the tool asks, I ask, through just an Excel spreadsheet. So when you research HIPAA, do not fall for snake oil. Go to the source. Go to HHS. There's a lot of things being peddled out there that aren't entirely true, using fear or just misleading or plain ignorance because folks don't know because the law is not explained very well. HHS has good frequently asked questions area. Ask them questions if you need to. That's what they're there for. It's what our tax dollars pay them for. So be careful what you read online. There's a lot of folks using fear, and this is a fearful law. I mean, I'm not trying to say that, but, fact check. Very good document here, which goes through the entire security and privacy and breach notification rule. It's about 115 pages, straight from HHS, straight from the source. Don't worry, 115 pages, but a lot of that's glossary and index, but you're getting it straight from the source with this document. So, in conclusion, there is no such thing as perfection. Just remember that. We are not expected to be perfect. Breaches are going to occur. The government never talks about being 100% compliant. We just need to follow the security and privacy rule standards, and this is a quote from HHS, implement the proper policies, procedures, and technologies, and reasonably show we are making an effort to protect against common threats and vulnerabilities. Now, to show that we are doing that, we have to do these things they ask of us and they require of us, doing risk assessment, writing our policies and procedures based on the findings of the risk assessments. That's the key. Got to be proactive. I cannot stress this enough. I don't want someone calling. I hate it when folks call. They're getting sued or they've had a massive breach and they had nothing in place prior to that happening. That's when you have problems. If you have a breach and you had policies, you had mechanisms in place to limit the risk, but it still happened because they do, you're not going to have a problem. The government's very reasonable as long as we've been reasonable. So that is all I have, and I will open this thing up for Q&A if you guys have any for me.
Thank you, Ben, for the presentation. Now we will open the line for Q&A session. Anybody having a question can raise their hand by clicking hand button, which is down right hand corner of your screen. Also, you can send your questions in the chat window. It seems there is no questions at the moment. However, you can still send your questions to email webinar@compliancekey.com. With this, we will end the session. We appreciate your time and believe the session was informative and up to your expectations. Soon you will be receiving the certificate of attendance and a feedback form. Kindly send your comments. Your feedback is important for us. Thank you very much for your time and have a good day. Thank you, Brain, for the presentation.
Thank you. Thank you. You have a great rest of the day. Bye-bye.
Happy weekend.
Thank you. You too.